Good day everyone, and I hope you're safe and well. I'm Sofia Cassandra D. Reyes, and for today, I'll present to you the case of the petitioner Marlene Loden Hernaez versus the respondents Honorable Wilfredo de Los Angeles, Judge of the Court of the First Instance of Quezon City, Hollywood Far East Productions Incorporated, and Ramon Valenzuela. General Register Number is L-27010, dated April 30, 1969. Before anything else, let me present to you the facts of this case. The petitioner Marlene Loden Hernaez is a motion picture actress. She filed a complaint against the respondent, Hollywood Far East Productions Incorporated, and its president and general manager, Ramon Valenzuela. After then, she filed a petition for a writ of certiorari to set aside certain orders of the Court of First Instance of Quezon City in its civil case number Q10288, dismissing the complaint for breach of contract and damages, denying reconsideration, refusing to admit amended complaint, and declaring the dismissal final and appealable. Let us proceed to the other information of this case. The petitioner herein is Marlene Loden Hernaez. She claims that she is an actress of motion pictures, wherein the respondent owes her 14,700 pesos, representing a balance allegedly due for her services as an actress. She filed a petition for writ of certiorari to set aside specific orders of the Court of First Instance of Quezon City. When the respondent court dismissed her first complaint, she filed for reconsideration of the dismissal and admission of an amended complaint. She further claims that the second motion for reconsideration was merely pro forma and did not suspend the period to appeal from the first order of the dismissal because 1. It merely reiterated the motion for reconsideration, and 2. It was filed without giving the counsel for defendant appellee the 3 days notice provided by the rules. Following the respondent's claim, the first motion was dismissed because the petitioner's claims were not supported by any written document, either public or private, and the complaint was defective on its face for violating Article 1356 and 1358 of the Civil Code of the Philippines. For the decisions of the lower court, principally, the Court of First Instance of Quezon City dismissed the complaint of the petitioner due to lack of evidence and was defective on its face for violating Article 1356 and 1358 of the Civil Code. Therefore, the petitioner filed a reconsideration for the dismissal. However, the court denied the reconsideration for being pro forma. The allegations are more or less the same as the first motion and were not accompanied by an affidavit of merits. The petitioner then resorted to this court, wherein they stated that the argument of the petitioner is not tenable because the second motion of reconsideration was addressed to the court's refusal to allow amendment to the original complaint, and this was a ground not invoked in the first motion of reconsideration. Thus, the second motion to reconsider was not really pro forma, as it was based on a different ground. Even if its first part is outlined in greater detail, the arguments against the correctness of the first order to dismiss. The court further stated that the contracts are valid and binding from their perfection regardless of form, whether they be oral or written, which is a plain from Articles 1315 and 1356 of the Civil Code. Therefore, costs will be solidarity paid by private respondents. The issue herein is whether or not the order of the Court of First Instance to dismiss the motion was erroneous. The disposition of the case is the order dismissing the complaint is set aside, and the case is ordered remanded to the Court of Origin for further proceedings, not a variance with this decision. Lastly, the dictum. According to Article 1315, contracts are perfected by mere consent, and from that, the parties are bound not only to the fulfillment of what has been expressly stipulated, but also to all consequences which, according to their nature, may be in keeping with good faith, usage, and law. In Article 1356, contracts shall be obligatory in whatever form they may have been entered into, provided all essential requisites for validity are present. However, when the law requires that a contract is in some form in order that it may be valid or enforceable, or that a contract be proved in a certain way, that requirement is absolute and indispensable. On the contrary, Article 1357 states that if the law requires a document or other special form, as in the acts and contracts enumerated in the following article, the contracting parties may compel each other to observe that form once the contract has been perfected. This right may be exercised simultaneously with an action of the contract. Again, this is the case of the petitioner Marlene Dodden Hernaez versus the respondents Honorable Wilfredo de Los Angeles, Judge of the Court of First of Instance of Quezon City, Hollywood Far East Productions Incorporated, and Ramon Valenzuela. General Register Number is L-27010, dated April 30, 1969. Thank you for listening and have a great day.